for the live. Okay, great. Hey, everybody, it's me, Elektra, artist visa lawyer located in New York City, the heart of the arts world, the capital of everything artistic and creative. So I'm in my conference room today. As I said, I would show you guys the awards that we won, just to piggyback off yesterday's live that I did late last night. But I'm going to show you the awards just because I said I would do it. But again, the real a professional achievement for me, which was kind of like the topic that we were discussing yesterday, professional achievement, is winning very difficult cases. So these are just some of the awards that we won this year. So we won, I don't know if you guys can see this. It's like law firm of the year. The National Black Association of Lawyers, top 40 under 40. Recognition in immigration law, another law firm of the year. I think these law firms of the years are really nice because it really showcases the hard work that the team does. And this is like the Funky Award. I love this award. Look at this. I don't know if you guys can see this, but this is the Titan Award. I think it's very nice looking. Okay. Again, yesterday we talked about professional achievements and how awards are not necessary for a professional achievement. So let's talk about what is an actual professional achievement for me, right? For a lawyer. The professional and artistic achievements that you guys get as clients and as artists are going to be different than us. But this is going to allow me to talk about something that is very important. And this is basically RFEs, right? RFEs are something to be expected. Denials are some things that happen. I know nobody wants to hear the truth, but today I just received an email, for example, for record high denials for O1 visa stamps occurring in Europe. So this is not good. If you're located outside of the US and you have to undergo visa stamping, this means that you're going to have to get approved by USCIS first. Great, if you're approved. And then the next step is to get approved by the Department of State for the visa stamp to be able to travel into the US. Essentially, to travel in and out of the US is what the visa stamp serves. So we received an RFE for a case that I thought was actually very strong, of a person who is a architectural designer, so somebody who is a designer and works on multi-million-dollar properties here in New York City. So you don't need to be a rocket scientist to know that real estate and real estate capital here is really important. We have some of the tallest buildings in the world, some of the most interesting architecture designed by famous architects. I mean, it's very obvious, right? And this client was working on multi-million-dollar properties. So again, most people would think like, hey, this is somebody who has a really strong case, just as I did. She had a really strong case. Her country of origin was a little bit problematic. Sometimes this happens. Sometimes you can be from a country that USCIS highly scrutinizes. You can go and research online the approval rates and denial rates for your nationality. It's all public knowledge. The Department of State publishes it every single year. So client, strong profile, maybe didn't have 5 press articles, but had like 3 press articles. I mean, was still a strong case. So client gets a massive RFE. So you can usually tell the severity of the RFE based on the length of pages. So if you get like a 13-page RFE, it's pretty bad, right? If you get a 1, 2, 3, 4-page RFE, maybe they accepted one criterion, so it's not so bad. It is fightable. In this client's case, she had, I think, a 13-page RFE. So essentially, none of the criteria were accepted in her petition. So all the criteria that I argued, the 4 criteria that I argued in this very beautiful portfolio, none were accepted. Obviously quite devastating for a lot of reasons because the client is from a Middle Eastern politically unstable country. So a denial means that this person has to go back home. So there's that. And there's also the fact that she works on multi-million-dollar properties. We're not just talking about properties that have a value of like 1 million or 2 million. We're talking about like $100 million properties here in New York City. So again, if you're watching this and you're like, oh my God, if a person like that got an RFE, I'll probably get an RFE too. I would encourage you to not think that way. Unfortunately, it's very random. And I have lots of examples of why things are random. And the only thing that you can do as an artist applying for the O1, working with an attorney, is to prepare and anticipate as much as possible, with also a healthy dose of understanding the risk, right? You can present a beautiful petition. There's always a risk of there being an RFE. Case in point, very strong case, received, you know, dumpster truck RFE, basically terrible RFE. So client gets the RFE, devastated. She can no longer work because she no longer has underlying status. And essentially she's very fearful that she's going to have to go back home. Again, I really strongly believed in this case. I knew that this was USCIS error. I knew that USCIS basically just submitted to us a boilerplate RFE because, again, it was very templated, no analysis, et cetera, et cetera. So what were my tips? What did I do to win this case? So it's very high stakes. I did not want this client to go back home. What did I do to make this case more believable or more persuasive compared to the original underlying submission? So the O1, we call those the underlying submissions. When we get an RFE, we call that the RFE response. So how is my RFE response different from the underlying O1 submission? So short answer is more legal arguments, more legalese, more pulling out the big guns, such as policy, law, federal regs, et cetera, et cetera. But really, what it can't only be that, right? It can't only be that I included like a bunch of suggestions that's what encouraged them to approve the case. Remember, this is a discretionary approval. They have their discretion to approve or deny. It's not like 2 + 2 = 4. Think of it like 5 - 4 or 5, 7 - 5 = 2. There's a bunch of different ways to get to the 4 in the O1 scenario. So what did I do? So number one, I pointed out to them in a very succinct way, which I already do in the underlying petition, but I did it in a more succinct way, all the evidence that was included and all of the new evidence. So we included an index, which we always include, but this index that I do for RFEs are different than the indexes that I do for the underlying submissions. So my index that I included was a table, right? My philosophy is people don't like to read, more so officers who are working on big cases that are this size. They don't really like to read. So what do? I try to make this as visually dynamic as possible. So my RFE indexes are in tables, which include caps, bold, red, underlines, so that I can make it interesting for them to read. And in my index, I point out the previously submitted evidence. So I actually, again, name out every different form of evidence that's submitted. And then I also include a list of the newly submitted evidence. Now, which do you include newly submitted evidence first, or do you include previously submitted evidence first? That's strategy, right? It really is going to depend on the case. In this client's case, I included newly submitted evidence first. So within my index, I connected the evidence to the law and to the project, and I wrote it down for them very nicely in a table, and each criterion had its own table. So very simple and easy for them to digest. And that's at the top of my RFE response. So you get the RFE original notice. You're supposed to submit back the original notice. So the original RFE notice, my brief, her brief was around 51 to 55 pages. And then I put the index. So they have the opportunity to connect the brief to the index. And they also have the opportunity to connect the index to the evidence. Everything is, how can I say it? The same thing, but in different formats. So the legal brief is basically the legal version or the legal presentation of what's included in the evidence. And the index, think of that as like a cheat sheet, a very beautiful, visually dynamic cheat sheet. So that's a third thing that they see: RFE, original RFE notice, legal brief, and then the index. So if they don't even want to go look at the evidence, they don't need to. Everything is enumerated very nicely and connected to the evidence within the index. So that's the first thing that I did. I made a very visually stimulating index. And the second thing that I did is my RFEs have a very specific format, right? Where I try to keep everything organized by criterion, right? And I always include what I think is the strongest criterion first. both strongest, and number two, what is easy for them to internalize and digest. So a big thing about O1s is that they are abstract, they're high concept, right? So lead role, critical role, these terms like don't really exist. They don't really mean anything, right? So it's more difficult to digest a lead role or a critical role as opposed to a press article. So I included her press articles first. This client did not get new press. I had to re-argue the previously submitted press. In the previously submitted press, I included full-on excerpts, right? Full-on excerpts in my legal brief. So they did not need to go and look at the actual press article if they didn't want to, right? In the original O1 submission, we did not include excerpts. And frankly, I almost never include excerpts because it makes the brief longer. There are certain attorneys, they don't even submit a legal brief for O1s. They will just submit an evidence list. Again, not knocking them. Everyone is stylistically different. Everyone internalizes researches a lot differently. We don't do that. We include the index and we also include the full-on brief, right? I just don't want to give them room for misinterpretation, which is why we include that very airtight data. So again, I included press first, right? And the press first, I included the excerpts within my legal brief. So they could actually, in that same document, read, right? Remember what I said at the beginning of this call? People don't read. People do not read, right? Most people just don't look at words and long sentences and lots of pages the way, they used to, or the way, a lawyer is supposed to. So I put it very nicely in italics, very beautifully presented for them to see. So number one, the visually stimulating index, and number two, incorporating excerpts of the press articles of the client actually inside the legal brief. And number three, this is something new that I did with this client. We routinely prove the background information of the press that we're submitting, the circulation numbers, the social media numbers. We do all of that in the underlying submission. So what I did was I created and I crafted my own legal argument on why they cannot reject certain forms of data. I have also an additional legal argument as to why they're so archaic and they refuse to accept printouts of the internet, as if they don't use the internet on their own. Like USCIS tries to reject printouts, which is legally and factually incorrect. And it's just a sign of how archaic they are, of how how they just don't evolve with the times. A press article is no longer uniquely in print. It is also in a digital format, right? So you've got to accept the digital format because that is where we are within technology. I don't think I should have to explain that, but I always include that argument in an RFE. This time, though, I included an additional legal argument about the press sources, and I included it in the first 2 pages. Usually it's on probably page 8. I included this in the first 2 pages. And I asked also for supervisory review because this was such a nonsensical RFE that I included their tip. I included mini versions of my brief on the second page, asking for supervisory review. So basically, if the supervisor gets which they're supposed to get since I asked for it, if the supervisor gets my RFE, and in that brief on the second page, I have many boilerplate, or sorry, not boilerplate, many bullets of arguments, of legal arguments of why the officer who reviewed my case made mistakes. I think that's actually very, very persuasive, right? I think that saves the officer a lot of time. And I think that shows the officer hey, she was able to condense 50 pages in 5 sentences, right? And of course, you have to write in a very persuasive way. You have to persuade them to approve the case. So all of this is essentially a lot about form, a lot about format, and a lot of persuasion, right? Persuasion is very important because that's literally what a petition is. We're persuading them to focus on specific facts that speak to the criteria. So I hope that this was helpful, but I really want to stress that RFEs are normal. It doesn't mean that you are getting denied. It doesn't mean that the attorney didn't do a good job. In fact, I can guarantee you that 8 times out of 10, it is not an attorney error. So a lot of the times I will I'll have consultations with people who get RFEs from other attorneys. And I will always be quick to say it's not the attorney's fault, right? Again, people have different styles, people have different ways of presenting data and information, but that does not mean or equal to bad lawyering, right? I might have more experience because I've been doing this a really long time and I've seen a wide range of cases, but somebody who presents their case differently than me does not mean that he or she is a bad lawyer. So I always preface that. And like I said, 9 times out of 10, when you're interacting with a non-lawyer, which is the immigration officer, you're going to have misunderstandings. In fact, gross misunderstandings of the law, of the policies, of the federal regulations. So it's almost always a them problem. It's almost always they misunderstood the law. It's almost always they ignore the evidence, which again, they're not allowed to do. It is illegal to ignore evidence which is within the administrative record. So it's really, really, really important to when you're going through this O1 process, having a good dose and a strong understanding of risk. Like, yeah, we work really hard to ensure that the cases are approved. We have a nearly perfect approval rate. But you also need to accept that an attorney cannot guarantee an approval. There's no guarantee that a case is going to be approved. In fact, that would be like malpractice. That's not something that that a licensed attorney following the rules of ethics can actually do. So let's Mino Brea. Does every time I get denied with you, is it another fee? Does every time I get denied with you, is it another fee? When my cases get denied, and I say when because it does happen. Statistically, it's going to happen. I don't want it to happen, but statistically, if we're filing like 100 cases a month, statistically something is going to happen. It's math, guys. I can't control it. They also have quotas that they need to meet, which are independent of like my lawyering abilities. A new case, yes, equals a legal fee depending on how we agree to argue the new case. So anytime I have to do legal work, yes. If you want me to do legal work, yes, I have to be compensated for my time. So hard to prove someone isn't reading or acknowledging. Actually, it's not hard to prove at all. It's like remember when you were in class in school and you had like a book to read or something, you had like specific pages you needed to read. And the teacher would ask you like, so what was this chapter about? And you would give very generic responses. I can tell when a client does not read my email based on the questions that they're asking me. I can tell when somebody has limited knowledge on a subject matter based on the questions that they're asking me. So hard to prove someone isn't reading or acknowledging? No, if you have experience, it's not difficult to prove. I can always almost see the holes in the analysis of the officer. I can also identify the type of tone that the officer is using. And that also helps me in determining whether or not I believe we should fight the RFE. So if the RFE is drafted in such a tone that I strongly suspect that he or she, the officer, wants to deny the case, that's going to influence what legal advice I'm giving my client. So I hope that answers your question. Again, I would really strongly recommend you not thinking that it's the attorney's fault. There are some bad attorneys, just like there are some bad doctors, just like there are some bad actors. I mean, there are bad apples everywhere. It has nothing to do with the law. So because these are complex cases, then does it ever get overturned? There are legal mechanisms to appeal the case. Yeah, it can happen. I don't necessarily recommend it. But yeah, there are legal mechanisms that exist to appeal a denial. But again, I would, if you're choosing the right attorney, and most attorneys, I would say, want to do a good job, want to get a case approved, I wouldn't necessarily go and start to think like, oh, it's bad lawyering or it's the attorney's fault. Because I can guarantee you 9 times out of 10, it's the non-attorney making mistakes based on the law. Lawyers who know the law will not usually make a mistake on the law. They might have a strategy that doesn't work, which is very different. Sometimes you can utilize a strategy and it doesn't work. That doesn't mean that they didn't know the law. A non-lawyer, which is an officer, making a legal decision with very limited experience on the law, 9 times out of 10, they're making the error. I mean, it's sad to say, and that is just the reality that you're going to have to accept if you're going to go through this sort of like transactional process with your future, at least here in the US. Of course, when you are in immigration removal proceedings, which I hope nobody is under, right? If you're being removed in immigration court, which is very high stakes, then of course it's adversarial. It's one attorney against the government's attorney with an actual judge. In the service centers, they're not attorneys and they're not judges, right? And that leaves a lot of room for incompetence. They're understaffed, they're underpaid. It leaves a lot of room for misunderstanding of the law. It leaves a lot of room for sloppiness, right? It leaves a lot of room for them to make errors because what do they care? I mean, they're honestly, they're still going to get paid whether you get approved or not, right? It's not their reputation on the line. An attorney who's representing a client, right? That's their reputation. They want to produce good work, and most of them, the attorneys that I know that we liaise with, that we support as well, they all want to do a great job on their case. But what I want you guys to understand is RFEs happen. RFEs happen, RFEs can happen. And the best way to approach the RFE is to actually have a game plan, is to actually have a strategy. And what is really unique about our law firm is that once you get an RFE, when you get an RFE, if you get an RFE, we provide you with an RFE strategy chart. We give this to you 10 business days after the RFE is issued. It's a really nice chart, and it helps you understand what is missing with each criteria. So this is, again, I think really important and a really great thing that we do, because 2 criteria, they're called the twin criteria, they have 2 prongs to it. So it's actually like 2 major criteria, but it's actually 4 small criteria as well. So conceptually, it looks different, but I break it down for you so that you understand, okay, what am I missing for my contracts or my future work? What am I missing for my past work or my portfolio? So I break it down so that it's easier for you to understand. But those are my tips for winning an RFE. A beautiful, visually stimulating index, excerpts of the press within the brief, and number 3, condensing the legal arguments at the top of the page or at the top couple of pages of the document of the legal brief, and asking for supervisory review where appropriate. You don't want to abuse it, but sometimes there is a gross misapplication of the law and incorrect analysis where it would be appropriate to ask for supervisory review. So yeah, I mean, if you have any questions, I'm happy to answer them. I got a request to talk about the difference between like O1s and L1Bs. And I told the person I would try to talk about it, but L1s are business visas. They're very different than O1s, which are artist visas. So I might go and do a video about like L1s and why I don't think that they're appropriate for O1s, but it's a very strange request. I almost never get them. Most clients want, or most potential clients, they want to know about like, what are things that they can do to improve their professional profile? So one of the things that you can do, like we were discussing yesterday, is to get more artistic achievements. Don't focus on awards, which is not a requirement. Get more artistic achievements. So hopefully this was helpful. Hopefully it clarified kind of what happens with an RFE, and how you should approach the RFE, and the game plan that you should have, and the rationale that you should develop in approaching this so that you can actually win. Because again, you can get multiple RFEs with a case. It's not typical, but yeah, you can get 1 or 2, or you can get more than 1 RFE with a case. But you always want to have strategy, right? With O1s, the name of the game is strategy. You don't want a cookie cutter strategy. You don't want like a boilerplate strategy. You want someone who really understands what you're doing and what your creativity entails to be able to make those arguments. So it was great seeing everybody. I will be back tomorrow. Like I said, I'm going to be live every single day until the election. Maybe I'll be live during the election. It's a federal holiday, but maybe I'll be live so we can talk about like what's going on, who's winning, and what changes that may mean for the O1. So it's very nice talking to you guys. I will be back tomorrow. Again, any requests, send me an email, DM me, go to the website, get all of your free resources. Those nuggets of knowledge are for you guys to utilize until you're ready to start your O1 journey, hopefully with our law firm. But nice seeing everybody, and we will talk tomorrow. Again, I don't know which time I'll be live. It really just depends on case filings. I've reviewed a couple of cases already, so they're ready to be filed. So I'll be back tomorrow. Bye, everybody.